Oke, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everybody. Before we start, just to make sure that you can focus on your phone, then please not focus on your phone, focus on our lecture today. So please put all the phones on your pocket or in your bag, and then make sure that the bag should be below on the table. Okay? And if you want to use electronic devices, make sure that you disconnected to Wi-Fi, and also you can only open Microsoft Word or Notes on your electronic devices. So today we have a very distinguished guest. It's coming from far away, and he's from Nigeria, from University of Bayero. He is Associate Professor Dr. Kabiru Adamu, and he is an expert as well on international law. And today, with a very special time, we invite you to get more explanation and knowledge about the Nigerian private international law. Without further ado, I think I will give the microphone back to Dr. Kabiru. But please, for students, you may have an assignment to make minimum one-page handwritten summary. Okay, and then as part of the assignment and attendance, so after you finish, then you can collect all the papers to me, and then it has to be minimum one page. Okay, so please, Dr. Kabiru, the time is yours.
Thank you very much, Dr. Dodik. I'm still happy to be here. I've been here for like 3 to 4 days. I'm still enjoying myself and interacting with various people and students here at your own university. So I'm here to share ideas and experiences with you with respect to how private international law works in Nigeria. So unfortunately, I don't have slides for you, but however, I will just make some few points, then we interact, because the essence is just for you to know how private international law works in Nigeria. And I shall be asking questions to see whether students are following me. So, to begin with, we all know what international law is, right? We know international law. So, international law basically is the law that regulates the relationship between states and non-state actors. So, by state, we mean countries. Countries that are recognized under international law, based on the Montevideo Convention of 1933. So that particular convention now spells out the necessary ingredients for a state, a country. So for instance, it talks about permanent population, right? That a country must have permanent population. So the population, when they say permanent, it means that it is not a migratory population, meaning a population moving from one side of the country to the other side. And it doesn't have to be a country that has massive land. It can be a country with islands, right? Just like the way we have it here in Indonesia. So that is number one. Then number two, so when we say non-state actors, we are talking about international organizations like the United Nations Organization, like the African Union, and the rest, right? So that is for international law. And we all know that international law is divided into two: public international law and private international law. So public international law is that branch of the law that has to do with the rights and duties of countries. So here international law is interested in the actions, the non-actions, and the omissions of countries. So here we are talking about all those rights that states have. Right to enter into diplomatic relationship, right to enter into a treaty, and the rest and so forth. So here, public international law again, this with all those use cogents, right? Rules of international law that has to do with basic issues relating to prevention of torture, right? Prevention of genocide. So all that branch of law, which in most cases you find it under customary international law. Am I right? So that is for public international law. However, with respect to private international law, if you look at private international law, is that branch of international law that deals and regulates the relationship involving foreign entities. Right? So in public international law, what do you have? You have states. You have countries. So international law laid down rules and regulations for them. But in the case of private international law, it is regulating the relationship involving foreign entities that has to do with those foreign entities transcending national borders. So basically here we are talking about conflict of laws. Hope you understand. So that is the demarcation between public international law and private international law. So why is private international law important and relevant for international law? It is relevant because it deals with some cogent important issues under international law. For instance, here you talk about jurisdiction. Whenever there is any issue involving foreign entities, which country or courts of a country have jurisdiction? The number two, private international law is also important because it deals with the choice of law. Which law do you apply whenever there is conflict? So let me give you a practical example now so that you can understand. Let us say I will do it jokingly, Dr. Dodik. Maybe Dr. Dodik decided to give me a lady to marry here in Indonesia. So I'm in Nigeria, right? So we have an Indonesian lady. She agrees to marry me. So that means I am regulated by Nigerian law. She is regulated by Indonesian law. Assuming now we married and we have children, I decided to go back to Nigeria. And maybe she wants to get some rights from me. She wants to sue me in Nigeria. Don't forget that she is not a Nigerian. She is an Indonesian here. So if she goes to Nigeria, she wants to sue me to get her rights. Right? So in this case, which law do you apply? Is it Nigerian law or Indonesian law? So that means you need to choose the law that you want to apply in this respect. So, and most important thing is private international law is important with respect to recognition and enforcement of decisions. So assuming there is a decision that is passed maybe in Indonesia. So like the practical example I gave you, instead of her to go to Nigeria to sue me, she decided to sue me in an Indonesian court. And the Indonesian court now gave her rights. So how can she enforce that right when I'm in Nigeria? Are we together? So here she will get the judgment given to her by the Indonesian court here. She will go to Nigeria. When she goes to Nigeria, how can she enforce it against me? Because she's not in Indonesia. Now, I'm not in Indonesia. Do you get the point? So there's the issue now of enforcement of foreign judgment or award. And in most cases, you tend to see this in cases of arbitration. I hope you all know what arbitration is, right? There is international arbitration under international law. So instead of entities to go to court whenever they have dispute. What do? They go to an institution. They now appoint arbitrators. And these arbitrators are not judges, but they are knowledgeable in arbitration. So they will now decide that particular issue and they will give an award. So if you have an award now, how do you enforce it? If you have an arbitral award. So this has to do with private international law. So this is just the background as to what is international law, divisions of international law, public international law, and private international law, and what do you do? So the next issue now is, how is private international law applicable in Nigeria? So now we are talking about my country, right? How does private international law apply in Nigeria? The first thing to note is that private international law is a branch of international law. So it applies in Nigeria, just like public international law, especially when it involves foreign elements. But you see, the problem with private international law in Nigeria is unlike public international law. Why? Because most Nigerian lawyers and judges were more interested in public international law and not private international law. The reason is because private international law is somehow confusing. It's not easy to understand like public international law. So because of that reason, most judges and lawyers don't have interest in it. So that means that it's a gap in knowledge. Although you tend to see lawyers in a way practicing private international law, but as a concept, as an idea, as a rule, they don't know. You understand? Because of this difficulty in understanding it. So that is the first point. Private international law, although it exists in Nigeria, our lawyers, our judges are not interested in it because of its own complexity and difficulty. Most of the principles of private international law relating to conflict of laws are difficult for our lawyers to understand. So this is something you need to know. You understand? I don't know the situation here in Indonesia, how private international law applies, and the competency of lawyers or advisors when it comes to private international law issues. So that means there is a gap in understanding private international law in Nigeria because we focus more on public international law that has to do with actions of states and non-state actors. So now, what are the areas covered by private international law? Basically, we need to know this. So one, for instance, family issues, family law issues. Like the example I gave you, right? Me marrying an Indonesian lady. I'm a Nigerian, she's an Indonesian. So now she has a right that she wants to enforce against me. So it is a family law issue. So private international law comes in and not public international law. Number two, arbitration cases. So private international law also applied to arbitration cases in Nigeria. And in the case of Nigeria, it is very interesting because we've had many and several arbitrations. And these arbitrations are in commercial contracts involving the government or involving companies. And that is a lucrative area for many lawyers. So for us, some of us that are lucky to have studied abroad, so we were taught arbitration and arbitral processes. So you tend to see oil and gas companies, energy companies, especially from abroad, coming into Nigeria to do business, either with government That is one, or with other international oil companies. So they design the arbitration agreement. They put a clause, a provision in the arbitration agreement that in the event there is dispute, that matter should not go to Nigerian court, but rather it will go to arbitration. And in most cases, the seat of arbitration, that is where they will do the arbitration, will be either in London or in France or in other jurisdictions. So this is an area that private international law through arbitration applies. Then number 3, private international law applies in Nigeria when it comes to matters relating to succession and administration of estates. Succession. Property of a deceased person. So here somebody has property, he has a lot of children. Maybe some of these children are in Germany, some are in Indonesia, and he's from Nigeria, right? So he has property. So now, how do you administer that property? How do you give his child that is in Germany that property? Where do you go to institute the case? So this is also covered by private international law. And lastly, private international law apply in Nigeria in the case of foreign judgments and arbitral awards. So later I will tell you how we do this in Nigeria. But for now, all we need to know is that if there is a judgment in any of the countries of the world and you want to enforce it in Nigeria, it will conflict with Nigerian laws, right? And that is where private international law comes in. And here you need to register the judgment before you enforce it. You understand? So, like I said, private international law is very, very important and relevant to Nigerian situation, especially when it comes to cross-border transactions, cross-border trades and transactions. Because Nigeria now do a lot of transactions with countries, right? It trades with China, it trades with Japan, it trades with Indonesia, and it also trades with countries in the African region. So this has to do with cross-border trade, agreement, and dispute. Then private international law now becomes relevant, especially in the context of Africa. We have the African Continental Free Trade Area, which we call ACFTA. So this particular rule was created for Africans so that they trade easily. And I think maybe you have it here in Asia, right? Where Asian countries can trade freely with each other based on certain rules. So the question now is, if there is dispute, what do you do? So that dispute in relation to Nigeria will be regulated by private international law. So now, for us in Nigeria, because most lawyers are not experts, they don't have expertise in matters relating to succession and administration of estates when it comes to private international law. They only have some semblance of knowledge when it comes to arbitration and arbitration cases. You understand? They don't have expertise when it comes to the choice of law. Which law do you apply when there is conflict? Or they don't have enough knowledge when it comes to family issues. So now they always rely on arbitration and enforcement of foreign judgment. So now, if somebody has a judgment relating to a particular issue, subject matter, like for instance, like I said, family law, family issues, or arbitration, How do you now enforce it in Nigeria? Like I said from the introduction, you will see that if you get a judgment from a foreign country, you don't just go into Nigeria and enforce it. You can't do so. What do? You now try to domesticate that judgment that you have or award. And there is a process and procedure because of conflict of laws. So practically, assuming there is an arbitration between Nigeria and a company in Indonesia, like Pertamina, you have Pertamina? Pertamina. So let us say there is an arbitration relating to a contract for oil and gas exploration in Nigeria. And Pertamina now entered into contract to do so in Nigeria. But they now put or insert a clause, if there is dispute, they should go to arbitration. And that arbitration will take place in Indonesia, in Jakarta, for instance. So now, there is dispute. They now go to Jakarta. They now do the arbitration. And Pertamina has a judgment. That judgment in arbitration is called award. So how do you enforce it now against Nigeria? Because you need to go to Nigeria, right, to ensure that that judgment given to you is enforced against Nigeria. If they are to pay some money, they pay it, right? So now it creates conflict of laws. And private international law comes in now. So the question is, how do you do so in Nigeria? First thing is, you must register. You must register the judgment or award. How do you do the registration? You take the judgment or award to the Federal High Court in Nigeria. In Nigeria, we have hierarchy of courts. What do you mean by hierarchy of courts? We have different types of courts, and each court has jurisdiction, areas that it can entertain when it comes to dispute. So for us, if you want to enforce a foreign judgment, you go to Federal High Court. The reason is because we have our constitution, which is called the 1999 Nigerian Constitution. And under section 250 of that constitution, it says that any dispute involving federal government of Nigeria, any dispute that has to do with agency of federal government of Nigeria, you should take that matter to the Federal High Court of Nigeria. So you will not take it to other courts, like the Court of Appeal or Supreme Court or the High Court of a state. You take it to the Federal High Court. So that's the first thing. You need to register the judgment or award with a Nigerian court. And that Nigerian court is called the Federal High Court of Nigeria. So, before they register the judgment or award for you, you must show them the judgment that you have. And when it comes to this, you have to show certified true copy of the judgment. So practically, you have a judgment given by an Indonesian court here. The Indonesian court must now issue you something like a certificate telling you that this judgment comes from the High Court of Indonesia. Then it will be signed by the officer. It will be stamped by the court. So the court in Nigeria need to see that. Number two, you need to do what is called an affidavit. An affidavit, I don't know what you call affidavit here, but in Nigeria, an affidavit is a statement that you made in writing, which you swore under oath before the court. So that means that judgment that you have from Indonesian court, you want to enforce it in Nigeria, you must have a confirmation from the Indonesian court that it comes from Indonesian court. Number two, you must write an affidavit and swear it before a court. Don't forget that all of this will be done for you by a Nigerian lawyer. Not you, by a Nigerian lawyer, because he is aware of it. Then, after this is done, the court will now look at all these documents. So, like the example I give, me marrying an Indonesian lady, we have a child, and now she wants to ask for money, maintenance, to take care of the child. But I'm in Nigeria, right? So she can come to Indonesian court and say, my husband is in Nigeria. My husband is not paying maintenance, food for my child. So I want you to pass a judgment awarding me money so that he will be forced to come and pay the money. So when the court does so, she will get a certified true copy of the judgment. She will go to Nigeria and meet a lawyer. The lawyer will register the judgment for her. And most important thing is for the court to go over to see that, one, the parties are properly named. What does that mean? It means that my name is Kabiru Adamu, that I am Kabiru Adamu. It should not say Muhammadu Kabiru, because there are two different names, right? So that must be confirmed before the court asks. Then you need to do that within 12 months. You need to register the judgment within 12 months. 12 months is 1 year, right? If you don't do so, then it will not apply. Then in the document that you are submitting, you must state my residence. You must state my business, the type of business activity that I do. What does this mean? For instance, in Nigeria, we have states. Just like in Indonesia, we have Jakarta, we have Yogyakarta, we have Bali, right? So in Nigeria, we have states. We have Lagos State, we have Kano State, we have Kaduna State. For me, I reside in Kano State. So the award that you have or judgment must indicate that I live in Kano State, so that the court will not make mistake. Then lastly, the court will review the documents. Then thereafter, if there is the need for your lawyer to come before the court and convince the court, make argument, legal argument, as to the possibility of you getting any right, then he can do so. Another condition before private international law in relation to enforcement of judgment is applied, the country where that judgment comes from must have entered into a treaty with Nigeria. So that is called reciprocity treaty or agreement. So what does this mean? It means that if you have a judgment from an Indonesian court or an arbitral award, you want to enforce it in Nigeria, then Nigeria and Indonesia must have entered into an agreement whereby they now give each other the rights for each of their citizens or entities to enforce judgments. If that agreement is not in place, then you cannot enforce your judgment. So this is based on these two laws. So let me give you the name of the laws. The first law is the reciprocal enforcement. That is the name of the law. The reciprocal enforcement of foreign judgment ordinance of 1958. Then the second one is Foreign Judgment Reciprocal Enforcement Act of 1990. Have you taken that? Or you can do your research and get it, right? So these are the laws that lay down the condition for you to now enforce an arbitral award. So basically, these are the issues that are covered by private international law in Nigeria. However, like I said, there is always complexity when it comes to the understanding and application of private international law in Nigeria. And most lawyers are not vast. They don't have knowledge about this area. You understand? So, in the event there is a dispute between foreign entities and you want to apply private international law in Nigeria, then you have to get someone that is knowledgeable or has basic information about how private international law works in Nigeria. Most especially in relation to family law issues and in relation to arbitration. Because you tend to see that in the past, many Nigerians went to Russia and Soviet Union then for studies. So when they went there, they married. You understand? And they had children. But they left after they finished their studies and went back to Nigeria. So those children and their mothers now want to get rights from those Nigerians. But they couldn't do so because they don't know about how private international law works in Nigeria. Do you understand? And even if they get a lawyer that will help them to do so, the lawyer himself does not have much knowledge about private international law. That is one aspect. Second aspect is in relation to arbitration. Arbitration is a good area now where lawyers in Nigeria make money. You understand? And we have had several arbitrations. This arbitration shows how private international law applies and the weakness of private international law in Nigeria. So let me give you one example. There is a case between Nigeria and a foreign entity, a company, which is called P&ID. That is the name of the case, P&ID. So, P&ID is a company that was registered in Scotland, United Kingdom. So they entered into an agreement with the Nigerian government to construct an energy station. But however, they could not construct it because of corruption. Why? Because they said that they are going to come with counterpart funding, money from their own side, that they will construct the energy station, and Nigeria will give them land. Nigeria will give them tax relief. All this was done in an agreement. And they gave timeline within which they are to conclude that transaction. Then they put a clause in the agreement. In the event that they couldn't be able to finish, then they will go to arbitration. And in the course of that arbitration, they now put some amount of money that Nigeria should pay. Unknown to many Nigerians, it was a scam. P&ID was a scam for the purpose of taking Nigerian government to court, knowing that they are not going to fulfill the transaction. So Nigeria couldn't be able to conclude the transaction, and P&ID took Nigeria to an arbitral panel in UK, and judgment was given against Nigeria. So now, P&ID wanted to enforce that award because the award was given to them. So they want to go to Nigeria and enforce it, and they found it difficult. And these are some of the challenges of private international law in Nigeria, because the government officials at times are corrupt. You understand? So corruption has a role in giving problems to private international law in Nigeria. So at the end of it, that award could not be enforced. Nigerian government decided to go to UK to challenge the arbitral award, and they succeeded. So these are some of the problems of private international law in Nigeria. In addition to that, other challenges that we have has to do with we don't have much books written on private international law, unlike public international law. So lawyers find it difficult laying their hands on good books explaining what private international law is, the principles, the rules and regulations. So currently we don't have much. In most cases, we rely on foreign books from the UK and in most cases from the United States of America. So there is gap in the knowledge. So these are some of the problems of private international law in Nigeria. So these are the little things, Dr. Dodik, that I will say about private international law in Nigeria, what it means, how it applies, the challenges and problems that it poses for our country and for our students. And I forgot to add that in Nigeria now, we don't teach students private international law at undergraduate level. We don't. Because we have few experts. Like in my faculty now, only 2 of us know something about private international law. Only 2 lecturers. So we now teach them at postgraduate level, master degree level, and PhD level. So thank you very much, Dodik. This is what I can say about private international law. Thank you.
Thank you very much. Okay, you can give applause. Wow, so we try to compare the private international law in Nigeria and also in Indonesia. Almost we have the same scope and the same definition. So based on the explanation from Professor Kabiru, we know that private international law is something that regulates private relations which contains foreign elements. So that is why Professor Kabiru also mentions about the relationship could be foreign entities, it could be also with the persons. But mostly foreign entities, when they have making a contract with the other foreign entities, then their contract can be considered as a contract that governed by private international law. And at the same time, we also understand that private international law in Nigeria also regulating mostly on family law, and then about the succession of property, and then about foreign judgment and arbitration. And in Nigeria, I mean, because you also have adopting the common law system, so mostly these kind of terms that used by Nigerians are conflict of laws. Because in Indonesia, because we are civil law, then mostly when I see their own courses, their name is a private international law. But they both have the same name, but only the options and the choice is depending on the state, whether they want to use the term of private international law or conflict of law, but those are the same. And do you have any federal law regulating about specific on conflict of laws, or these depending on the court decisions?
We have federal law. In Nigeria, there are 3 systems of law. There are laws that are passed by the federal government. So those laws are called acts. Then there are laws that are passed by states, and those are called laws. Then there are laws passed by local governments or city councils and city councils. So they are called bylaw. Bylaw. So local governments or city councils, they pass law that is called bylaw. So in relation to private international law, it is national law, the federal law, that regulates some aspect of it under statute. But you see, private international law is regulated by 2 laws in Nigeria. One, common law, like you said, common law principles, So most of the common law principles, we adopt them and use them to interpret conflict of laws. The number two, statutes. And these statutes are federal laws made by the federal government of Nigeria, not by states. So state law does not do that. Then secondly, we rely on interpretation by courts. The courts now used to interpret the position of the law to say this is the meaning of a particular issue when it comes to conflict of laws. Thank you.
Thank you. How many federal states do you have?
We have 36.
Six. 36. 36 federal states. And they have their own law, and particularly on conflict of laws.
No, they don't have.
Oh, they don't have only the law, the act, the act, the acts. Okay, so they have a harmonization of the law. So mostly they are adopting the same patterns of on private international law. When we see that in practice in the common law, if, for example, somebody from one specific federal state and then they marry with the other wife, the wife is coming from the other federal state, is that considered as private relations which contains foreign elements? No,
It is only considered private relation
private relations
within
only.
the regulation of domestic law. So not within private international law. So here, like the last sessions I had with some students, where I taught them English legal system, common law legal system, right?
Yeah.
And I taught them about customary law and Islamic law. So in this respect, if you have somebody from one state marrying another person from another state, then the law that will regulate is the law which the parties agreed to.
Okay. So the parties has an option.
They have
to
option.
use whether this will be civil partnership or
Yes,
religious
or
partnership.
religious partnership.
Okay.
So, in the event that they were silent on the position, then if they go to court, then the court can interpret the transaction based on the actions, conducts of the parties.
Okay.
So, for instance, I'm a Muslim, I'm Hausa, I'm Fulani. So, if I go to Yoruba side, some of them are not Muslims. So, I marry a non-Muslim lady now, right? So, naturally, she has her own law. I have my own law.
Yeah.
But English law can regulate the two of us. So, if we couldn't agree, the court can now look at our conduct and say English law should apply.
Okay.
Because in this case, we have two different laws and they conflict with each other.
Okay.
So this is under domestic law, but not under private international law.
So there is a possibility for Muslim and non-Muslim marrying in Nigeria, just because of the English law may apply for
Yes.
these circumstances.
Yes, of course.
And how about LGBTQ partnership? Do they also recognize it under
No, we
Nigerian
don't.
law?
We don't, because you see, Nigeria is a religious country. So we have Islam and Christianity as the major religions. So that is one. The people do not condone that kind of relationship. Gay rights, you understand?
Yeah.
Then issues relating to women marrying women.
Yeah.
No, the custom does not allow it. Religion doesn't allow it. And we have a federal law
You have federal law.
which criminalizes gay relationship.
Okay.
Yes, so that means gay relationship in whatever sense.
Okay.
Although people hide,
Yeah.
and do their things. But if they are caught, the law will apply.
So though they married abroad and they got legalized, for example, in UK, and then they come back to Nigeria, then in Nigeria it can be criminalized.
It is a
and
criminal
it is,
act.
Okay.
Yes.
It is illegal.
It
under,
is illegal.
Under Nigerian law, because in Indonesia we don't have any criminalization for that. So there is no strong point for us to make sure that those marriage are illegal. But
illegal.
we use the public policy concept.
Okay.
The root is coming from our morality, our traditions, and also our customs. Students, I know that I have some discussions with him just because I'm so getting more inspiration and also knowledge from him. But if you have any questions, just raise your hand, and then you may also mention your name and your student number so I can put your name in my notes. Is there anyone who wants to address questions to Dr. Kabiru? Yes, please. You can use the microphone.
Thank you so much for the time. My name is Maki Zakaria. My student number 244 10 3 236. And uh, yeah, it is very interesting to know about the private international law in Nigeria. As you said as well, that in Nigeria, the challenges of Nigeria private international law is unwritten. So until now, there is no book about the private international law. And it said as well that in Nigeria, is allowed to get married with different religion. It is legal. But in Indonesia, as we know that it is forbidden to get married with different religion. So for example, there is person from Nigeria, he is non-Muslim, and come to Indonesia, and he want to get married with Indonesian person, and the Indonesian person is Muslim, so it is very prohibited in Indonesia. And uh, if they want to get married in Indonesia, uh, I mean, is it possible to get married in Indonesia? Because in Indonesia we are not allowed, and but in Nigeria is allowed. So what do they want to do? Okay, that's my question.
Because you are asking about whether they get married in Indonesia, right? Because I know Indonesia. He knows Nigeria, right?
Yes. So you can comment.
Okay, but is there any other question? I think Mustafa also wants to address question, right? Because you want to live and stay in Nigeria. Yes, Imelda, please. You should have question. Mulia.
Hello, my name is Imelda Rahma Subandi with the student number of 244-10769. And I would like to ask that, um, as short as I know, that nabis in idem is a general principle of law, and it is recognized under international law also. I would like to ask you, in Nigeria, did they recognize nebis in idem, and how did the principle of nebis in idem apply there? Thank you. Yeah, did Nigeria recognize nebis in idem, the principle of double jeopardy? Yeah. Okay. Yeah. Thank you.
I think I will try to answer your question first. So there is a possibility for Indonesians if they are a couple having different religions marrying. In Indonesia, it's strictly prohibited, but if they marry in Nigeria, that is possible. But and it is considered legal under Nigerian law, right? Under the Nigerian law, and then after that, their documents can be proceed and registered in Indonesia, so that the Indonesian government will recognize their marriage. But if they intentionally married in Indonesia, then Indonesian government through units under the ministry, we call it as KUA, Kantor Urusan Agama, Religious Affairs, Office for Religious Affairs, and then they may reject your application to marry with non-Muslims. But if you marry in Nigeria, they are okay it is legal under Nigerian law, but you have to get the document, and the marriage document, has to be bring before the Indonesian district court, and then the district court will recognize your marriage coming from abroad. Then after they got recognition from the district court, then they can divorce in
divorce.
Indonesia.
Okay, good.
Yeah,
Good.
that is the process. We already studied it last time, yesterday, last week, with the rights and obligations created abroad. Any Melja question should be for you. Do you have
Thank you
any
very much.
any dumb principle?
Yes, we have. And for us in Nigeria, it's even a constitutional issue. What do you mean by a constitutional issue? It means that we have it in our constitution, the natural law of Nigeria. So you see, in Nigeria, we have hierarchy of laws. So, and the highest law that we have is the 1999 Constitution of the Federal Republic of Nigeria. So that constitution specifically talks about double jeopardy. You understand? It recognizes it because of the implication that it has, the rights that it has, you understand? And the rights that can be taken away by double jeopardy. So it's a constitutional issue. And a lot of cases have come before the Supreme Court. And the Supreme Court was in support against double jeopardy. You understand? So thank you very much.
Thank you. Is there any other question? Yes?
Okay, sure. Okay, good afternoon, sir. My name is Fadil Gunawan with student number 244108873. So I have this certain question. What if, let's say, Indonesian state-owned enterprise, let's say Pertamina, have some conduct in Nigeria? They have agreement with Nigeria, and they can, let's say, open a business in Nigeria. But in those process, they accidentally doing injured of like Nigerian citizen, let's say they doing tort, can like, and the Indonesian state-owned enterprise Pertamina stated that they have immunity because they are state-owned enterprise in Indonesia, well, from Indonesia. Can the Nigerian court like reject their immunity because their conduct is in private actor? That's my question.
Even my friend from Nigeria told me, if you want to marry Mustafa, you have to make a note, Nigerian lady, then you can use the Indomie, the noodles, as part of your marriage gift.
Yeah.
So they will definitely say yes. Okay?
Yes.
Yeah.
Doctor. Okay. Doctor, you are right. On a lighter note, Nigerians like Indomie. I don't know why.
Very fast.
Then, on a lighter note again, our women prefer Indomie. You understand? They like to cook Indomie for their men more than other food because it's easy to make. You just do it within 1 second. You understand? So thank you for that question. It's a good question. And you see, these are some of the principles under private international law. Issues of immunity. You understand? Because you tend to see that some foreign entities, whenever they go into some foreign jurisdictions, they try to claim immunity. You understand? Why? Because they are afraid of liability. But you see, within that context of immunity, this is where you tend to see relationship between private international law and public international law. They used to somehow mix together. You understand? So in this respect, what do I mean? There are situations in which Pertamina cannot claim immunity. It cannot claim immunity. One, because the nature of our own laws in Nigeria is when you come to operate as a foreign entity, you have to now subsume to yourself, give yourself the right to go under national law. Because national law will have to apply to you because you are within another country. So what do I mean by this? You need to register a local entity. So you have Pertamina Indonesia. It wants to do business in Nigeria. Then it has to register as Pertamina Nigeria Limited. It must register. You get the point? If it cannot register this way, then it must be given permission. Let us say the contract is for 1 year. Then permission will be given to Pertamina Nigeria Limited for 1 year. But you come under national law. So if that is the case, then you will be subjected to national law. So that means if there are labor issues between Pertamina Nigeria Limited and a laborer or an employee, then that employee will sue Pertamina, a local court. Naturally, when Pertamina lawyers come to the court, they will argue that we are a foreign entity, right? They will claim immunity. But the court will overrule that. Because already you have to register as a local company. You have to undergo a local process before you do business. You get the point? So this is where you tend to see the relationship between private international law, national law, and public international law. So that is the position. Thank you.
Yeah, and I also want to add, because this is also my area. That's a good question as well. So if you are state-owned enterprise or the majority of the shares owned by the state, then you cannot claim the immunity just because we have the legal basis. Here we have the UN jurisdictional immunity, the UN Convention 2001. In those convention, Article 10, it is stated that if the company is doing business, then there will be no immunity. They are adopting the restrictive immunity. So we call it as acta iure gestionis in Latin language. So if you are doing business, even though you are a state officials, even though you are a state units, or even though you are coming from the state-owned companies, then you cannot claim immunity. Because after all, if you use and claim immunity, then this will no justice in between the parties. The contract has to be reliant on the freedom of contracts, and the party has to honor the contract. So that is the important principle in answering your question. Is there any question so far? Yes, Imelda again. How about the others? I see like Achwa. Do you want to ask question, or Nesha, or Ayo? Don't be silent. Mulia. Maybe you can ask, is there any gorengan in Nigeria? Because you like gorengan.
Okay, sir. I would like to, ask from like your answer that no matter like what they came from, if they come to the other state to do business, then it will fall under the juri gestionis, and they will cannot claim the immunity. But I would like to ask, what if the business is to the benefit of the business is to let's say upgrading the state, like it's for the sake of the state. Yeah, benefit of the state. Can it still consider jure gestionis, or can it claim immunity? Like, are there any chances that that a state-owned enterprise can claim immunity? Thank you.
That's a good question. Then I confuse who is the speaker now in this. Okay, so that's a good question. So practically, in the business area, I know that the state now are involving in doing business. There are so many state-owned enterprise, but I see that in civil law countries there are more state-owned enterprise. just because the level of the government, the democracy, and they don't have even sufficient companies who is really well established and so on. So many civil law countries, they also have more and more, and also undemocratic governments. They have state-owned enterprises, but at the same time, this is also benefiting with the citizens, but also benefiting for the powers, just like maybe the presidents, the family, and so on, because they are involving in the business. Then, but I see in some countries, like in common law countries, like in UK, in India, I don't know, in Nigeria, in Australia, in America, they have Foreign Sovereign Immunity Act. I don't know, do you have it in Nigeria? You have it, right? In Foreign Sovereign Immunity Act, in those act, it is clearly stated that whatever the situations, if the state conducting the business, it has to be limited, no immunity. Because, for example, if those companies making financial losses and those losses will affect to the other party, then the party has the right to ask the compensation. This is the definition of the contract. This is the philosophy of the contract. But mostly big businesses, they are not going to the court. They are going to the arbitration. So though they are asking the compensation, then the arbitration panel will try to measure not much, not less, but at least to make sure that both of the parties will have a favor situations. So those are the functions of the business nowadays. But we see that some of the, like we have people, Democratic Congo, they were also doing business in China, and they are also in Chinese doing business in Congo, UK enterprises doing business in Congo, but they claim immunity a lot. But it depends on the government. It depends on whether they have the law restricting the immunity or not. But the philosophical basis on that measure is just because we want to honor the contract. We want to make sure that the parties have their rights and obligations. Okay. How about the others? Do you have any other questions? I have question. If my student marry with Nigerian, hopefully maybe Rajasa, you have a plan to marry a Nigerian lady, maybe Bubu, because we have Bubu here, Faidat. Um, then they married and started in Nigeria. Is that difficult for them to marry? Is that Nigerian applied easily, or because the husband is from Indonesia, then Indonesian law will apply for this marriage?
So this is a practical question. You see, one thing is this. There is no barrier to marriage in Nigeria. That is one thing. Even though you tend to see people having different religion, different culture. So, but it is when it comes to the rights that the parties have, that's when you have problem, because that's when the conflict comes in. So you will see that we have a lot of Nigerians marrying abroad, especially when they go for studies or when they go for business. Or Nigerians being married by other people. So in this particular case, it will not be difficult for him if he's a Muslim. That is one. It will be easier. So even if he wants to marry a non-Muslim there, it will be easier because there is no restriction. You see, our culture encourages marriage. That the type of society that we have is they want union, they want children, they want family. So our laws are so flexible that they allow. Even if you have a foreigner coming in to marry, it is allowed. And you see, because of the nature of our economic situations, you tend to see ladies now wanting to marry foreign husbands. Why? Because they believe that if they go out, they will run away from the economic hardship in Nigeria. Hmm? They will have a lot of opportunities. Because Nigeria is a country that has serious economic problems, you understand? So, and the nature is people want to run away from that. So it's easier. So, but you see, if for instance, an Indonesian person wants to marry a Nigerian lady and they want to do it in Nigeria, then they have to follow the normal immigration process, he goes and that. But you see, we have a law which says if you marry a Nigerian, you take certain years, then you earn citizenship. It is easy, very, very easy. It applies in most cases, yeah. Islamic lawyers. Okay.
So you can marry in Nigeria. Any other questions? Do you have any other questions, Nabil? It seems like you have question, right? No? Mustafa? No? Achwa? No? How about the others? No? Okay. Maybe I will try to summarize this in bahasa. Just give me like 1 and 2 minutes. So, jadi ceritanya Nigeria ini memiliki kurang lebih 36 negara bagian. Tidak seperti negara-negara bagian di Inggris hanya ada 4, kemudian Amerika Serikat 50 karena besar sekali, Nigeria itu 36 negara bagian. Tapi uniknya Nigeria punya undang-undang. Undang-undang ini diterapkan di negara federal. Makanya undang-undang ini mengatur tentang hukum perdata internasional. Jadi kalau saudara punya rencana cita-cita seperti tadi Mustafa pengen punya cita-cita nikah sama orang Nigeria, tadi sudah saya tanyakan, Rajasa juga itu kan, maka nanti cukup bisa menggunakan hukum Nigeria kalau menikahnya di Nigeria. Tapi kalau menikahnya di luar negeri, maka sama seperti kita. Seperti pertanyaan Nabil tadi, maka ketika menikah di luar negeri dan kemudian sudah sah, maka hukum Nigeria melalui undang-undang federalnya bisa mengakui pernikahan mereka yang sudah sah di luar negeri. Tapi Nigeria punya batasan-batasan tertentu. Batasan yang pertama seperti misalnya pernikahan sesama jenis. Di Nigeria bedanya adalah mereka sudah menegaskan bahwa pernikahan sesama jenis itu masuk kategori perbuatan pidana. Sehingga siapapun yang melakukan pernikahan sejenis di luar negeri, sekalipun itu sudah sah, maka ketika mereka pulang ke Nigeria, mereka bisa dipenjara dan dipidana. Berbeda dengan di Indonesia, kalau di Indonesia masih bisa tinggal, kemudian mereka masih bisa sembunyi-sembunyi, tapi permasalahannya adalah mereka akan dikucilkan di masyarakat karena apa yang mereka lakukan kemarin kita sudah bicara itu bertentangan dengan moralitas atau ketertiban umum, public policy yang kemarin bicarakan. Dan kemudian di Nigeria konsep hukum perdata internasionalnya hampir sama dengan di Indonesia, di mana konsepnya hubungan hukum yang mengandung unsur-unsur keperdataan itu diatur dan mengandung unsur-unsur asing, maka kemudian itu diatur dalam hukum perdata internasional. Dan uniknya juga di Nigeria itu ada 3 sistem hukum yang berbeda. Hukum Islam, English law karena mereka dijajah oleh Inggris. How many years you were colonized by the British?
From 1861 to 1960.
It's almost 50 years more, right? Almost 70 years. Hampir 70 tahun dijajah oleh Inggris dan kemudian sehingga menggunakan hukum Inggris, common law system. Kemudian yang ketiga adalah hukum Islam. Jadi kalau ada Muslim menikah dengan Muslim di Nigeria, maka menggunakan hukum Islam. Kalau ternyata Muslim mau menikah dengan Kristen, maka dia bisa menggunakan hukum English law. Itulah keunikan di Nigeria. Tapi kalau di Indonesia dilarang, Muslim harus sama Muslim, non-Muslim harus sama non-Muslim. Maka cara satu-satunya cara agar Muslim dengan menikah dengan non-Muslim, mereka menikahnya di luar negeri. Itulah yang sering dipraktikkan oleh masyarakat kita. One more last question from me, I just came up in my mind. You know that you have Christian and also some of the others like Catholics, right? And they also drink alcohol. Then there is a business in alcoholic products. In our country, because we are majority Muslim, we are restricting the business of alcohols. And even in the Netherlands, they even recognize and accepting business in marijuana. And how about in Nigeria? Is that restricted? Or in some others, it is regulated by federal state law or any other?
Thank you very much.
Yeah.
So it is regulated by state law
The state law.
because like I said during my lectures on Nigerian legal system, Nigeria has different populations populating the states. So in the north, you have majority Muslims. In the south, you have majority Christians. So because of that, and because the law allows states to regulate commercial activities, then in the north, because they are majority Muslims, they regulate consumption of all illegal products in Islam. So it means al-hanzir, that is pork meat. It means alcohol and other business activities like gambling. Yes. So, but federal law, no.
No.
The federal law does not restrict people on the kind of business that they do.
How far the restriction? Is that only labeling, or they really strictly prohibited those meat coming to that
Yes.
state?
So in my own state, Kano State, which is predominantly 99% Muslims, no business of alcohol. So you can't open a factory and manufacture alcohol, beer, no. No selling, so you can't sell on the streets. Number three, you cannot bring in from other places. So that is the law.
Okay.
However, in practice, it's difficult
Yeah.
because there are areas whereby you have Christians, so they try to smuggle the alcohol. But in other states like Lagos, like Anambra, is majority Christian. So they do alcohol business, they consume it, and the state law does not prohibit it.
Okay.
That is
But
the
if
position.
Muslims comes to the south, do they find any challenges or?
No. So that means, for instance, because there are some Muslims that consume alcohol,
Yeah.
they hide and consume it.
Yeah, yeah, yeah.
So those from the north, when they go and they want to consume, they consume. And they will not be asked why. Because the environment allows it. Yes. So, but you see, the nature of Nigeria, like we said, is a kind of environment you have many people moving from this side to that side, this side. So there is semblance of acceptance. So much so that if you are a Muslim, you go here, then you won't have any problem.
Okay.
Thank you.
Oke, good, thank you. Jadi di negara-negara bagian Nigeria ini juga baru, ini informasi saya, ini belajar banyak dengan beliau. Di 36 negara bagian di Nigeria itu, sebagian yang bagian utara itu mayoritas Muslim. Kemudian di sebagian bagian selatan itu mereka mayoritas Kristen. Dan di mayoritas Muslim, negara-negara bagiannya itu mengatur sendiri-sendiri, membolehkan, mewajibkan 100% harus halal, kemudian tidak membolehkan ada daging babi, tidak boleh membolehkan ada alkohol. Tapi di negara-negara bagian selatan itu diperbolehkan. Bahkan boleh ada pabrik bir, bikin bir di sana, dijual sendiri, bikin sendiri, dan memasarkan sendiri. Nah inilah salah satu perbedaan yang kita miliki dengan mereka. Mereka mengatur ada yang berbeda-beda di setiap negara bagiannya. Saya kira mungkin itu, and thank you very much again for your abundance knowledge again. For me, I think I really want to move to Nigeria and to learn more. Maybe next time, if I have another opportunity, I will try to take a postdoctoral program there, maybe, inshallah. And thank you very much. Let's close our session today by hamdalah. Alhamdulillahirabbil alamin. Assalamualaikum warahmatullahi wabarakatuh. And before that, before you go out, make sure that you collect the papers to who is the leader of this class? Mustafa. So please collect all the papers to Mustafa. Okay. And then after that, we need to have a photo session. I think we need to stand up here. And